Welcome, everybody, to Berkeley Law Clinical Program CLE in partnership with our wonderful Berkeley Alumni Relations team. I'm Laura Riley, Assistant Dean of Clinical Education. The clinical program is made up of 15 clinics, and we have a joint mission of advancing racial, social, and economic justice. We provide students with a foundation in law and practice while hands-on client work helps them build critical lawyering skills. I think some of you have already participated in our clinical program, those of you who are here, so we're excited to welcome you to this program. If you have any ideas for future CLE topics that you're interested in seeing, please let us know in the Q&A function later on. But today I am happy to introduce Mridula Raman, the Deputy Director of the Death Penalty Clinic. She will discuss pregnancy criminalization, pre-Dobbs, post-Dobbs, key cases and developments in abortion criminalization, topics she is very well versed in since she recently developed and taught a course here at UC Berkeley Law on pregnancy criminalization. Before I hand it off to Mridula, I want to note that instructions for how to ensure you receive CLE will be popping up in your window, and there will be some time for questions in at the end of the presentation. So if anything occurs to you, feel free to drop it in the Q&A. I'll be tracking that, and Mridula will turn to those toward the end. And feel free to add any questions in at any point along the way. Thank you all for joining, and I will hand it over.
Thanks so much, Laura. I am just going to share my screen and hope that everybody can see that. Hi all, thanks so much for joining me today. I'm really excited to be here. As Laura said, I'm Mridula Raman. I teach in the death penalty clinic at Berkeley Law. And I know a lot of you have ties to DPC or to the clinical program broadly, and it's really lovely to see you here. And I'm really looking forward to spending some time today talking a bit about pregnancy criminalization, which is a phenomenon which has a long history in this country and has taken on even greater urgency in recent years. This presentation will be a high-level overview of a big topic, so it's pretty introductory, and I'm just going to touch on pieces of preg crim. And I will be pretty heavily focusing on criminalization as opposed to, for example, efforts to defund Planned Parenthood or the FDA's review of the safety of abortion medication. So I've tried to narrow it in that way. So let's dive in. I thought I'd just walk through the agenda first. I'm going to give a quick intro to what pregnancy criminalization is and what's happening currently. Then I will give a sense of some of the history of pregnancy criminalization, how we got here. I'm going to talk through how one prosecution in Alabama has played out. And then I'm going to talk about specifically what's been happening with respect to abortion criminalization since Dobbs. And after that, we can do a bit of a Q&A. As Laura mentioned, if you have questions along the way, feel free to drop them into the chat function. Let's jump in. So what is pregnancy criminalization? Take a second to think to yourself, when you see this image, what is your first thought? And I will ask you to ignore the fact that this is a weird AI generated image. I'm sorry about that. But for me, my first thought is this concern about fetal alcohol spectrum disorder, which stems from having represented a bunch of clients in criminal proceedings who have deficits that are attributable to in utero alcohol exposure. It's certainly not a neutral response. And it's certainly not a response that centers the pregnant person's autonomy. And when I asked my students in pregnancy criminalization last semester this question, a lot of them said their first reaction was disapproval or concern. And so at an intuitive level, pregnancy criminalization is when this is legal, criminal law takes no issue with this. But this warrants surveillance, potential law enforcement contact, even criminal charges, conviction, punishment, and collateral consequences, which can include the most severe of consequences like losing custody of one's other children. So conduct that is legal for many people becomes cause for concern for the criminal system because the person is pregnant or even is just perceived to have the capacity for pregnancy. So that's pregnancy criminalization in a nutshell. And I just wanted to share one working definition. So it's when the state wields a criminal law to render acts associated with a pregnancy loss, birth, and/or associated healthcare the subject of criminal intervention, which could include surveillance, it could include arrest, it could include prosecution, conviction, um, any of things. So that's one working definition of pregnancy criminalization. And it includes abortion criminalization, but it also extends much more broadly, as we'll see. So next, let's turn to the numbers. What are we actually seeing in terms of charging? So we can get a snapshot of what's happening on the ground because of research done by Pregnancy Justice, a New York-based organization, and some amazing scholar researchers like Wendy Bach. And it is really difficult to track prosecutions that relate to pregnancy. There's no centralized resource or agency, even in a given state, keeping track of this. You actually just have to start doing FOIA requests and looking at charging documents. So it's a really complicated endeavor, but this is the most comprehensive set of research we have so far. So um, by the numbers, between Roe in 1973 and 2005, researchers identified 413 related cases. So it's about 12 or 13 a year. That number jumps between 2006 and Dobbs, and we get about 85 cases a year. And then in the 2 years after Dobbs, the number jumps again. We've had 412 pregnancy-related cases, cases brought against the pregnant person in the years post-Dobbs, and that's over 200 cases a year. So, some portion of this jump is due to the fact that, we have better resources to identify these cases, the more recent cases, but a lot of this is just more aggressive criminalization. Then, if we look at charges by state, we can see that this is a pretty concentrated phenomenon. All of the 412 prosecutions in the 2 years post-Dobbs have taken place in only 16 states. And really, Alabama and Oklahoma are by far the biggest drivers of these prosecutions, followed by South Carolina. And you'll see, for those of you who are in California currently, California is not immune. We've had a post-Dobbs pregnancy-related prosecution even here. And if we talk through the types of charges a bit, across the 412 prosecutions, there have been 441 charges. And as you can hopefully see from the chart, the vast majority of those charges, nearly 400, have been for child abuse, child neglect, or child endangerment of the fetus. And generally, that means substance abuse during pregnancy, mostly for meth, sometimes other amphetamines, and sometimes opioids. But in 175 cases, the quote unquote substance abuse was marijuana use. And in 7 cases, it was alcohol use, and there are a handful of cases in which it was nicotine use. And I also wanted to note that for 29 of these charges, the child endangerment at issue wasn't substance abuse or anything like that. It was a lack of prenatal care, which is kind of sometimes hard to swallow given that prenatal care is not universally available in this country and is much more available to some than to others. What about, the crime of abortion, like abortion as defined as a crime? We're not really seeing that charged against pregnant people. I will come back to that toward the end of this presentation. The one last thing I wanted to note with this chart is that the vast majority of charges did not require proof of any harm to the fetus. For 378 of these charges, there was no requirement of any harm, and often there was no showing of any harm or any indication of actual harm to the fetus. So, turning to some basic demographic info, we're seeing that most of the people facing charges are white, These numbers do generally match population numbers, and they are mostly low income. And that is indicated either by being indigent for court purposes, or there's some indication that this person got public benefits that are means tested. So with respect to race, this is not this has not always been the case. Pregnancy criminalization tools were first wielded most forcefully against Black women in the 80s and 90s. But when you build these systems of criminalization, they will get quickly deployed against other groups, including other marginalized groups. And it's now often poor white women struggling with addiction. So just to give you a quick summary of the what the numbers are showing us right now, we're seeing an accelerating pace of criminalization. We see that the vast majority of these charges are related to drug use while pregnant. Most people facing prosecution are low income, most of them are white, and these prosecutions are quite geographically concentrated, especially within 3 states. But even within these states, this is a phenomenon of certain counties. It's a phenomenon of certain DAs in certain counties who feel very strongly about fetal rights, which we'll talk about some more. And just so you know, this data is mostly from Pregnancy Justice, and the reports that they've issued, some of the more recent ones, are included in the CLE materials, and all of them are, of course, available on their website. All right, so how did we get here? I thought I would touch briefly on some of the assorted historical roots and drivers of pregnancy criminalization, and some of the through lines that we see over history that lead us to where we are now. We see the kind of earliest roots of modern pregnancy criminalization in chattel slavery. In chattel slavery, of course, forced pregnancies were common, and harming or killing a fetus was a criminal offense in some states, framed in terms of damage to the enslaver's property. Whereas for a pregnant person who was not enslaved, there was generally a born alive rule, which meant that an act against a fetus was only criminally punishable if the fetus was born alive and then the act occurred. That was not true for enslaved people, um, for whom an abortion was a criminal act. So from colonial times, we see a model of punishing pregnancy loss for certain people and for doing so differently based on race and based on status. And then I'm going to jump in time a lot during this, just to give you a sense of some of the drivers, but I want to talk about the eugenics movement. We see some of these same themes emerge in the late 1800s and early 1900s. Immigration is up, including among people deemed non-white, including Southern Europeans. There's more immigration by Chinese people. And we have in this country this theory, and more broadly, this theory that takes hold, which is that we can selectively breed to improve the human race. Um, there are two different aspects of this eugenicist approach. The first is to stem reproduction among non-white people and among white people who are deemed, unfit or undesirable. And these are people whose children would be, according to those in power, people whose children would be public charges. Um, would the responsibility for paying for these children would fall to the state. So that's the first part of the eugenicist approach. The second was to encourage reproduction by desirable white people. And so in this era, we start seeing forced sterilizations more broadly, including in Carrie Buck's case, which led to the infamous Buck versus Bell, um, where SCOTUS condoned forced sterilizations of undesirable people. And we also see efforts to encourage these certain favored groups to have more children and to protect their ability to have and support their children. So in this era, we further entrench this practice of saying, we can, as a society, control people's reproduction for the good of the human race. And we see this in a way that's deeply rooted in xenophobia and racism. So I'm going to jump ahead again several decades to the fetal personhood movement, and this is the probably the greatest driver of pregnancy criminalization now. So the anti-abortion movement started in the 1960s, and it gained a lot of steam in the wake of Roe in 1973. And a key part of this movement was entrenching the idea of fetal personhood, the idea that a fetus has the same legal rights as a person who has been born, the full panoply of human rights, and that this is true from the very moment of fertilization. And all of this is framed for this movement in terms of fetal rights and human rights, but it's as much or more about control. Because of course, if the fetus has rights, then those rights can trump the rights of the pregnant person carrying the fetus. And I think images like this are really telling. They're really common. If you start looking for them, you will see them everywhere. And here we have this image of a fetus that looks fully formed, but there is no pregnant person here. We've given this fetus full personhood, but we have erased the pregnant person altogether. And I think in some ways that's where fetal personhood ultimately ends. But just going back into the history, Roe, the decision itself, rejected fetal personhood. But the movement turned instead to state laws and state constitutions. They tried to seed the idea in state law that fetuses have legal rights, and they were exceedingly successful in the 1980s and 1990s and through to today. And so now we see fetal personhood established in areas from criminal law to torts to estates and trusts and beyond in every single state. And recently, many states have enacted fetal personhood laws that can be read to apply across their criminal codes. And there are just some examples on this next slide of such laws. The Texas Penal Code, for example, says that an individual includes an unborn child at every stage of gestation from the moment of fertilization until birth. And what that means theoretically is that an individual who was fertilized just days ago can be the victim of a crime. So fetal personhood has been a huge driver of pregnancy criminalization and a lot of what allows it to happen, these fetal personhood laws on the books. And the last movement or driver that I want to talk about is the war on drugs. And this coincided in the 1970s with the rise of fetal personhood. After Nixon relaunched the war on drugs, a study came out that I'm sure all of you are familiar with or heard of on the effects of crack cocaine on newborns. And it wasn't a study that looked to prove causation. It was barely a study at all. But it led to this virulent crack baby narrative that grabbed the nation. And it was really pushed by the media, really pushed, right? This false narrative about pregnant people using crack cocaine and producing a generation of zombie babies. These parents were poor, they were Black, and they were on crack cocaine. They couldn't pay the medical bills that their damaged babies would incur. These babies would become public charges. And so the media built up this image of a Black welfare queen using crack cocaine who's basically stealing from the government. And as we see the echoes of eugenics here, claiming this claims to be concerned about the harms to fetuses that'll become public charges. We again see the idea of unfit or undesirable parents. If they were good parents, they'd just stop using crack cocaine. It's easy. So to combat all of this, we criminalized. We have this wave of laws, of criminalization laws, targeting pregnant people for substance use. And most of these early cases of serious charges for pregnancy criminalization, including homicide crimes for substance abuse leading to the death of the fetus, are against poor Black women. And the CLE materials include one of the seminal cases in this space, the case of Regina McKnight in South Carolina. Regina McKnight was one such poor, unhoused young Black woman, and she was the first person convicted in the country after Roe for homicide based on substance use during pregnancy. And when you read the opinion, you read a lot of the court's sense of, well, we all just know that what she did harmed her baby, and we all just know that she made a choice here. So it's this really patronizing language that infuses the opinion, and it infused many opinions of the era and continues to infuse opinions to this day. So we have chattel slavery, the eugenics movement, the fetal personhood movement, the war on drugs, and modern pregnancy criminalization is the descendant of all of these movements and systems. It reflects all of the social ills that animated them, including white supremacy and anti-Black racism, xenophobia, misogyny, and class bias, and more. And just to sum up again, you have these notions. We end up at a place where a fetus is a person that has full rights. Reproductive choices are matters for external control and should be dictated by whether society perceives you as someone who should be having children and as someone who would be a fit parent. That society shouldn't have to bear the costs of children who might become public charges, and that you, as a pregnant person, have an obligation to your fetus and to society to not do anything that society deems potentially harmful to the fetus. And your failure to discharge that obligation is not like just social opprobrium or social censure. It is criminal consequences. And what happens is what started with the criminalization of poor Black women has now led also to the rampant prosecutions of poor white women for opioid or meth use during pregnancy. And I'm just going to note that as I see it, there's a clear through line from efforts to reform our population through pregnancy criminalization to the efforts to reform our population through, for example, ICE's brutality at the moment. So, with that history in mind, I wanted to walk through a one sample prosecution. And I'm going to talk about the prosecution in Lee County, Alabama, of Brooke Shoemaker. This case has gotten a lot of media attention, and Ms. Shoemaker herself has spoken to the press about her case, so I trust I'm not putting someone's name out there when they don't want that. And this case is emblematic of pregnancy prosecutions in key ways that I'll draw out. So I think it's a useful example to walk through together. So, Miss Shoemaker. Miss Shoemaker is a 37-year-old white woman in Alabama in Lee County, and she had struggled with meth addiction and had some prior misdemeanor convictions. In 2016, she became pregnant with her fourth child, and she tried to make a doctor's appointment for prenatal care, but she was turned away because she had unpaid medical bills from a prior pregnancy. So she wasn't able to get medical care. And just as a side note, if you recall earlier, some DAs have charged people with child endangerment for failing to get prenatal care. But back to Ms. Shoemaker, while pregnant, she used meth with a friend. And around that time, when she was 24 to 26 weeks pregnant, maybe it was a little bit later, she delivered a stillborn baby while taking a bath. She went to the hospital, and while she was in the hospital, she told them about her meth use. She told medical workers about her meth use. And then she spoke to a detective while still in her hospital bed. The detective had been summoned by medical workers. So a pathologist examined the fetus and found a tear to the fetus's liver, possibly caused by paramedics during resuscitation attempts, but it's not clear what the cause was. The pathologist also found a small hemorrhage on the placenta, And the pathologist ruled that the cause of death could not be determined. The coroner in the county was elected and had no medical training and decided to speak to or claim that they spoke to a different pathologist, one who had no specific knowledge of the case. But based on that conversation, the elected coroner listed on the death certificate for the fetus the cause of death as chemical endangerment. And so the state charged Ms. Shoemaker with chemical endangerment, and you can see the citation to the Alabama Code on the slide. The law criminalizes chemical endangerment for knowingly, recklessly, or intentionally causing or permitting a child to be exposed to a controlled substance. And the wording is actually even broader than that. So that's Alabama's chemical endangerment law. And this law wasn't meant for the circumstances here. This law was meant to protect children from noxious environments in meth labs. It hadn't been intended to by the legislature to apply more broadly. And we know that because one legislative sponsor introduced an amendment that would have expressly made this law applicable to pregnant people for substance use. And that amendment was rejected. The lawmakers voted that down. They did not intend for their chemical endangerment law to criminalize pregnant people for substance use. Nevertheless, relying on Alabama's fetal personhood statutes, the Alabama Supreme Court interpreted the criminal law to apply to substance use by a pregnant person. And certain DAs have used this really widely. This case came down in 2013. It's called Ex parte Ancrum. And, and chemical endangerment has become one of the leading causes of the incarceration of women in Alabama. So the state charged Ms. Shoemaker under this law. And the trial judge was actually unsure about whether there was even probable cause. And if you ever practice in criminal law, you know that probable cause is a low standard, right? I think even if, from 1L year of law school, you know that. But the trial judge was unsure whether there was probable cause and asked for a briefing on the issue of causation of death. The state provided one relevant case, and defense counsel didn't provide anything. So the judge allowed the case to proceed to trial. At trial, what happens is the medical examiner testifies and says that there was meth found in the fetus's blood, but the medical examiner could not say whether the drug had caused the fetus's death. There was no testimony that the drug had caused the fetus's death. Still, the jury convicted Ms. Shoemaker. It took the jury less than an hour to do so. And that same judge who had been concerned about probable cause, that judge sentenced Shoemaker to 18 years in prison. And I can't help but wonder, I actually haven't read the sentencing transcript, but I can't help but wonder whether that 18 years corresponds to how long the fetus would have been a child, legally a child, if it had been born alive. The judge did say he thought the prison time would help rehabilitate the Shoemaker. And all of this, like what happened in this case, really reflects a lot of pregnancy criminalization in key ways. Ms. Shoemaker was charged under a statute that wasn't meant to apply to circumstances like hers, but was expanded to her circumstances because the fetal personhood movement took hold and made incredibly strong inroads in Alabama in particular. Ms. Shoemaker spoke to medical personnel about her drug use after the stillbirth, and medical personnel then got law enforcement involved. And I think this has been for me, one of the really big surprises. Maybe it shouldn't have been, but it has been one of the big surprises for me is how often pregnancy criminalization begins with medical personnel. Um, According to one study, 2/3 of pregnancy-related prosecutions start because a medical worker initiates contact with law enforcement. And even in more conservative studies, they're finding that 1/3 of prosecutions start because of medical workers. Either way, large number of these prosecutions start with medical workers. The third thing that I want to point out is that the trial involved really shaky medical evidence, perhaps even junk science. And that's common in these cases, especially with miscarriages. It is often impossible to pin down the cause of a miscarriage. And hopefully, folks know that miscarriage or spontaneous abortion happens naturally all the time. Um, and And people have a lot of preconceived notions about the effects of in utero substance exposure on fetuses. And people assume that it necessarily can cause miscarriages and that it does. But some of that has absolutely no basis in fact. And the fourth thing I want to point out, so we talked about, the statute that was expanded to these circumstances, the involvement of medical personnel, junk science, or at least shaky medical science, and the harsh sentence, 18 years in prison, um, 9 years before any type of parole eligibility. And so despite the fact that this law ostensibly protects children, right? This is a fetal protection interpretation of the statute, and the statute is a child endangerment statute. The judge's sentence showed absolutely no concern for Brooke Shoemaker's other children. She's the mother of three children. So in this way and others, this case really does give you some insight into common factors across pregnancy prosecutions. And I did want to share one brighter spot in this case. Ms. Shoemaker filed a post-conviction petition based on newly discovered evidence that the stillbirth was due to a placental infection and not meth exposure. And just last month, in December, right before Christmas, actually, the judge granted the petition and tossed Ms. Shoemaker's conviction. At that point, Ms. Shoemaker had already served 5 years of her 18-year sentence. The DA is appealing the grant of relief, and Ms. Shoemaker is incarcerated pending appeal, but it is some good news in what is otherwise a pretty depressing presentation. Um, so that's Ms. Shoemaker's case. I'm happy to talk more about that or some other cases in the Q&A. And so now I want to turn to spend the next 10-ish minutes talking about abortion criminalization specifically. Like we've talked really broadly about pregnancy criminalization, but not with a focus on abortion. And so I want to spend this next chunk of time talking about abortion. So I'm going to, of course, post-Dobbs, states are free to criminalize abortion. And what's happening right now is we are exploring in different jurisdictions whether there are limits on what they can actually criminalize. And I think it's helpful to think in terms of who the targets of criminalization are or who they might be. And broadly speaking, there are three buckets. There are pregnant people. Sorry, I'm smiling because my former students might remember that I try to put everything in buckets, and I just realized that I'm doing that here as well. Um, so the three groups of people who might be targets of pregnancy or abortion criminalization efforts include, of course, pregnant people who seek or obtain abortions, people who provide abortions, and the helpers, anyone who, not the actual provider of the abortion, but who facilitates so that someone else can obtain an abortion. And I want to talk just a bit about pregnant people first. Abortion charges against pregnant people are very rare. For the most part, even in states with abortion bans, we are not seeing people charged with the crime of abortion or charged with some other crime where the entirety of the underlying facts or the bulk of it is that this person sought or obtained an abortion. But one thing we do see is that allegations that someone was considering an abortion have been used to support other charges. Um, they've been used to support, child endangerment charges in other cases. There was a good decision out of Maryland last year in the case of Maura Akers. Maura Akers was charged and convicted of murder after experiencing a stillbirth. And this conviction in Maryland predated the state constitutional amendment protecting reproductive freedom. The Maryland Supreme Court, after that amendment, held that the evidence that Sakers had looked into the possibility of abortion, had been considered an abortion, that couldn't be used against her at a murder trial, and the court vacated her conviction. So that was a great decision out of Maryland, but of course Maryland is a more protective state, and we wouldn't necessarily expect that same decision out of, for example, the Alabama Supreme Court. More broadly, at least 15 states have considered legislation that would explicitly make it murder for a pregnant person to get an abortion. South Carolina, you can see one of the headlines here. South Carolina is once again considering a bill that would make this potentially a capital crime, that an abortion could make you eligible for the death penalty there. And these laws haven't passed yet, and this new law that's currently being considered in South Carolina, it's unlikely to get real traction. But I do want to flag that some states already have laws on the books that would allow for prosecutors to charge people who get abortions with really serious crimes, certainly including murder. And in some states, there are laws on the books that would allow for someone to be charged with capital murder. So the risk exists. We're just not seeing it happen yet. Um, but it very well could. I think there is a lot of push among people who are anti-abortion, certain sects of them at least, to see much harsher charges against pregnant people. Um, there's actually, I mean, there is also a movement to just quote unquote treat all murderers the same and treat all people who get abortion as murderers. And it stems again from this idea that if a fetus is a full person with full human rights, the death of a fetus is no different than the death of a born person. So there is a real push in some corners for murder charges and even the death penalty for people who get abortion. I do want to note that states like California have enacted pretty powerful protections for pregnant people. Um, a bunch of states have done this at this point. And these protections preclude civil or criminal consequences for any pregnancy-related act or omission during a pregnancy. In California, this was enacted in 2022, and it's AB 2223. But I do want to flag that even these protections aren't impenetrable. I included in the materials the decision in Kelsey Carpenter's case. And that decision gives you, if you choose to read it, gives you a sense of where AB 2223's protections end. So she was prosecuted for some conduct during her pregnancy, and she had a live birth, a home birth, and then she did not clamp the umbilical cord of the neonate, and the neonate died. So she couldn't be prosecuted given 2223 for any of her acts or omissions during pregnancy, but her failure to clamp the umbilical cord is post-pregnancy. And the statute didn't protect her from those charges. So the protections are really meaningful, but depending on your policy preferences, they're not foolproof. So that's a bit of what's happening with folks who are pregnant. And it's really, I'm going to turn to providers. It's really providers who are facing the brunt of criminalization right now, in terms of actually facing charges, starting to face charges. Providers have long been targets of abortion criminal laws. This was true before Dobbs. This was true in the mid 1800s, when part of the reason for abortion criminalization was that licensed doctors wanted to take reproductive care out of the hands of abortionists. So the AMA sponsored or supported legislation to make the provision of an abortion without certain licenses a criminal act. So some providers have long been targeted, and most states with bans on abortion have criminal penalties in place that that penalize providers who violate these bans. And these are hefty, hefty penalties. You can talk about hundreds of $1,000s in fines, decades, some of these decades in prison. Texas's law allows for a 99-year prison term. So these are serious penalties that are at least theoretically possible. Um, some of the breaking news in this space has been that Louisiana indicted two providers for allegedly mailing abortion pills into Louisiana, where abortion is illegal. One is Maggie Carpenter, a New York-based physician, and the other is a California-based physician. Louisiana has sought extradition of both of these physicians, but Governor Hochul in New York and Governor Newsom have both said no. And they have said no based on their state's abortion shield laws, which preclude officials from cooperating with out-of-state legal actions taken against abortion providers in state. That said, Louisiana is setting up federal court challenges to these shield laws. This is all kind of an effort to take down these shield laws. And the state's AG, Liz Murrill, has said that she will take this to the Supreme Court if she can. Texas has also indicted 8 people who are allegedly practicing medicine without licenses and providing illegal abortions. Several of these people are undocumented. Ken Paxton called them a cabal of abortion-loving radicals, and these providers are facing felony charges right now. And there are more and more states that are considering bills that would create a wider variety of criminal consequences for a wider variety of actions for providers. For example, Indiana and South Carolina are considering bills that would, among other things, criminalize telemedicine provision of abortion medication. And lastly, I want to turn to the third group of people who might face charges, and these are the helpers, the people who facilitate abortions. And all kinds of people could fall within the sweep of existing laws criminalizing abortion. And some of them could be, principals under some really broadly worded statutes, and others could be accomplices to these crimes, or could be treated as accomplices to these crimes. But we haven't really seen anyone facing charges as in under an accomplice liability theory yet. The Alabama Attorney General is generally one of the more avid pushers of abortion criminalization. He did threaten to prosecute an abortion fund, the Yellowhammer Fund, that helps Alabamians get information and resources to travel out of state for abortion care. And the fund brought a pre-enforcement challenge in that case. And Judge Myron Thompson, who is in the Middle District of Alabama, he's a civil rights legend, he held that the Attorney General couldn't prosecute the abortion fund, and that the threat of prosecution violated the abortion fund's First Amendment rights, and also it violated the constitutional right to travel. There is also talk, as you can see in this second headline, there's talk of treating abortion support networks as a type of organized operation that could be attacked using RICO laws. We haven't seen this materialize yet, but it could well be in the offing. It's been a talking point among some anti-abortion lawmakers for quite a while now, several years, and this well might be coming down the pike. So before I open it up for questions, I just wanted to note that even though we haven't seen hundreds or thousands of people actually incarcerated because of abortions, Obviously, abortion access for many people has been gutted with huge consequences, including multiple people who have died because they've been denied timely abortion health care. Candy Miller, Amber Nicole Thurman, Nivea Crane, and more. And there is currently a civil suit against Arkansas's abortion ban by someone who is denied an emergency abortion. I just didn't want to stop talking without mentioning that, even though it's not necessarily strictly about criminalization of these folks, but generally the bans and the criminal regimes with these hefty penalties are what is allowing this to happen or what is ensuring that these people will suffer. Um, so with that, I will I'm happy to take questions, and I have some just resources up on this page. If you want additional resources, I mean, there are the CLE materials. These are just some good books and some organizations, but I have tons of cases. I have a full syllabus, resources for people working. If you are working on a case where your client is facing charges related to pregnancy criminalization or other types of related resources, happy to provide them. If anyone's interested, just shoot me an email. All right, I guess I'll stop sharing my screen and then go from there.
Thank you so much. I learned a lot and just want to invite folks to write questions in the Q&A, but maybe I'll ask a couple of my own first while people are still ruminating. But you mentioned, you talked about the case of Ms. Shoemaker, and I'm just curious sort of what's next procedurally in the process.
In her case
In
specifically.
her case, yeah.
So yeah, the DA is appealing, and the DA was very, very adamantly appealing, saying the level of meth found in the fetus's system was much higher than it was found in Miss Shoemaker's system when she was tested after delivery.
Hmm.
And so, I mean, it'll go through their standard process. So um, it'll go to the Alabama Court of Criminal Appeals, which is not the most favorable court for these kinds of issues. It's not a favorable court for criminal defendants in general, and this is a bit of a hot button issue right now. So I'm hopeful, but I'm not certain this will pan out for Miss Shoemaker in the way that I, as a criminal defense lawyer and as someone who cares about these issues from a reproductive justice perspective, would hope would hope for.
Yeah.
Sorry, that was just a really long-winded
Yeah, no,
way of saying like
yeah,
or
no,
nothing good.
yeah, I
But
was invested after hearing everything, so I wanted
yeah,
to.
but I do think the fact I don't want to lose the fact that the judge tossed the conviction. That's also huge, right? That was sad to say. Like that takes political courage, right?
Mhm.
These are elected local judges. So the fact that the judge tossed the conviction is a big win, and so maybe that does bode well. I just
Mhm.
have a bit of cynicism, maybe a
Yeah.
lot of cynicism, as someone who's also done a lot of work in Alabama on tough criminal defense issues.
Yeah, well, it sounds like we'll be able to watch it in the news. We have a couple of questions in the chat. One is about that you have some theories about the 18-year sentence and what theories do you have? And then the other one is about that the laws that propose murder charges for pregnant people who have an abortion haven't passed yet. And do you foresee them passing?
Sure. The 18-year sentence, so I think I'd have to recheck, but I think she was actually eligible for a much longer sentence even. Like it's
Mm,
not the Alabama law, the chemical endangerment law, the what penalty you're exposed to depends on whether there was any harm to the fetus. And if the fetus is dead, maybe it was 20 years, but it actually could have been, I think it was actually much higher than that she could have been facing. Um, so I do just 18 years seems to me like you have a child for 18 years. I think that's hard to ignore. Um, so that is my theory. And I have not heard judges in other cases impose 18-year sentences for rehabilitative purposes. It's generally more retributive goals in mind. 18 years is a long time. Um, but I'm going to go read the sentencing transcript and check that out. But yeah, I think I just don't see where else the judge could have gotten that number.
Yeah.
And it could have been recommended by the prosecutor, but it
Yeah.
seems like why that number comes to mind.
Why that number came to be. So then the other question was about that the laws that propose murder charges for pregnant people who have an abortion haven't passed yet. Do you foresee those passing?
Um, I think do I foresee them passing? Not really, but I am increasingly worried about it. Um, I think there has been, these laws, some of them have gotten quite a lot of traction before there has been a lot of public energy and attention on them. The first time South Carolina is kind of abortion is murder and therefore potentially capital murder bill, the first time that was sponsored, it had a ton of sponsors and a lot of support before there was a public movement to shut it down. The public attention on the law was very effective. I do think that as kind of public energy, there's so many places to focus right now and so many horrific things happening at the moment that it's hard to do everything at once. And
Hmm.
so it seems more likely that some of these laws will like have a chance to pass.
Hmm.
I
Okay.
think I think it depends. Like I think it's probably actually not in an election year that these pass. I think it's more likely at the start of a term. And there was one other thing. Well, I guess two other things I wanted to say. One thing is, as I mentioned in passing, but what we have is we have a massive fetal personhood laws and we have an existing massive criminal laws, and those interact in ways that allow for a lot of these charges even without new laws. So there are states in which you can face murder charges for an abortion even if no new law is passed, and even if the state legislature is like sponsoring and then not passing new laws, like if they're affirmatively not like rejecting them, that doesn't mean you can't be prosecuted under existing law. And those laws are on the books. They are hard to repeal.
Hmm.
There's just very little political will to repeal criminal laws, and there's no political will to repeal fetal personhood laws at the moment. And if this is of interest to someone, I've written an article on this, the prosecutorial discretion and the crime of abortion. You could check it out. It's really depressing, so I don't even know that I could recommend it, but it lays a lot of this out, this discussion about what laws are might pass and what might not. The other thing I wanted to flag on this is that not not long ago, even like less than 10 years ago, it was it was political death, really, or really bad move politically to talk about criminalizing, the terminology is like just criminalizing women who get abortions. Some might recall that I think it was 2016, then candidate Trump said, said something about like people who get abortions should be punished. And he very quickly had to walk that back because there was such blowback from a lot of different quarters. It was bipartisan blowback. That's shifted. That's really shifted. There's not nearly as much political blowback about this idea of criminalizing pregnant people. So I think that's one of the things that's going to enable the passage of some of these laws, or that would help facilitate it. It's not a political nuclear bomb in the way that it has been in the past.
So one question comes from, remembering something you began with about that criminalization, that most of the criminalization occurs in the child abuse or neglect types of cases. And the question is, do you have ideas for legal issues we can be raising on behalf of our clients in this sort of prosecution?
Yeah, so there are actually like full trainings on how to defend clients in these circumstances. I think the one issue, if I were to just pick one, I would really focus on, it depends on your statute. If the statute requires a harm to the fetus, I would really focus on that harm because that's actually like, I think it's almost never provable beyond a reasonable doubt. It's like very rarely provable beyond a reasonable doubt. Of course, we have the problem, like the science just isn't there. We don't understand pregnancy all that well. And we certainly don't understand the influence of like exogenous factors on pregnancy very well at all. So if there's a harm requirement in your statute, I would focus on that. I think if there's not a harm requirement, I would think a lot about the like how law enforcement got involved in the case. Are there, medical personnel, were they the ones were they the ones sharing this information with law enforcement, or was it someone who works for a public agency? Are there like Fourth and Fifth Amendment issues that kind of started this off? So there's been some success in, I think it was New Mexico, about getting some statements that were made to medical workers tossed. And then the prosecution couldn't proceed, and that's being appealed now too. But there have been some wins in that space. Happy to chat more offline or put people in touch with more resources. And there are organizations doing trainings on that exact question.
And then probably our last question is that do you anticipate that pregnancy prosecutions could expand in the future to involve allegations of not following CDC guidance regarding Tylenol use to prevent autism or, perhaps other CDC guidances?
I think that's one of the scariest things is we have no idea where this ends. I think that, yeah, I think it's possible. I mean, honestly, a year ago I would have said no. That maybe seems a little too far-fetched to me, but we've seen so much change so quickly that it doesn't seem entirely far-fetched to me. That we have seen historically, we're seeing currently charges for not getting prenatal care, and not getting prenatal care is both an act and an omission. It can be interpreted in either ways. So not doing something, either getting a vaccine when you're pregnant, um, maybe is not getting prenatal appropriate prenatal care, and or not prioritizing the fetus. Or we've seen people who've had civil issues around, not criminalization, but civil issues around uh, chemotherapy while pregnant.
Hmm.
So that's been a thing. So I think we could see, like, if we have it really depends on your local district attorney and what creative way of interpreting the statute that person is willing to espouse. And what will happen is if the penalty is high enough, this person will probably take a plea. And then that interpretation of the law will not get challenged. So I think we will see some wild interpretations of these statutes and people pleading guilty under them and just trying to, get out of jail, get home instead of like risking years in prison after an elongated process.
Yeah.
Sorry,
Well,
that was an
maybe.
incredibly depressing
Yeah.
note.
No, no. I mean, well, maybe this will be a more positive question to ask. I'm not sure. We'll see. You had
I'll find
mentioned
a way to spin it positive.
you had mentioned sort of that the potential suit against the Yellowhammer Fund. It seems like the fight back was around the First Amendment and also the right to travel. And I was just curious if either which of those or if both of those worked to sort of quash the suit or how what happened there.
I think I'm happy to share that's available online, that decision. I think the First Amendment has been pretty powerful
Mm.
in helping kind of abortion helpers uh,
Mhm.
fend off criminal statutes with these pre-enforcement challenges, because the First Amendment argument worked in Idaho too, and the Ninth Circuit or the district court struck down that statute. The Ninth Circuit said part of it can be enforced, but the part that violates the First Amendment rights of certain individuals, certain groups cannot be enforced. I think the First Amendment aspect of all of this has been pretty powerful.
Great.
So
Well, thank you so much, Mridula. Really appreciate you educating us on this important and increasingly relevant topic. And thank you all for joining. We really appreciate you joining this. If you want to see a taped version of this, this will be up on the website by next week. And we look forward to seeing you again at a future CLE.
thanks
Thanks
so
for
much.
being here.
Take care.